everyone, a very good evening. You're watching The Money Show on ET Now, your one-stop shop for all your personal finance-related questions and queries. I'm Ubina Kapasi and this is ET Now's Rise with India Prime Time segment. Well, before I kickstart The Money Show, I just want to talk about what SEBI has announced in their recently concluded board meeting. First up, sandbox regulatory changes. What exactly is sandbox? Well, to put it in extremely simple terms for all our viewers, when there is a new product that's introduced in the market for investors like you and me, or perhaps even, higher net worth investors to buy, before they do that, they will essentially test it out in a limited market. Hence the word sandbox, essentially. Also, a regulated entity can participate on its own in any fintech environment. We do know fintech, financial technology, has been reigning supreme of late. And additionally, lots in relation to an investment advisor's role as well. They've spoken about, norms with respect to clarity and fees. They've spoken about how the investment advisor is not going to provide distribution services, obviously because of conflict of interest, and to safeguard the client as well. That's clients like you and me. So their interest will be safeguarded as well. So that's some interesting pointers that has been released by SEBI. They've also essentially said that there's segregation of advisor activities, like I mentioned, at the client level to avoid any sort of conflict of interest. Also, here's something very interesting. A sponsor or an AMC shall invest in close-ended schemes as well. So let's say, just to give you an example, if Kotak has released a close-ended scheme, then Kotak, the sponsor, would essentially invest in that close-ended scheme as well. So here's just that quick update coming in from SEBI. Okay, meantime, here's all that we have lined up for you on the show. There was nothing with respect to the reclassification of mid-caps and small caps and large caps for mutual funds. But nevertheless, we on The Money Show are going to be talking, as always, about your money. Here's a topic we haven't touched upon, and that is legacy, financial legacy. What happens on the occasion, on the eventuality of your passing? Are you sure that you have left an organized legacy for your heirs to fall back on? We'll help you draft out the foolproof will so that your heirs don't have to worry later on. Your family does not have to worry about later on. Later on the show, it's yet another instance of big data breach. This time around, more than 500,000 credit and debit cards have gone on sale on the dark web. Not just that, reputed hospitals as well have seen big data breaches where patients' names, medical records, ailments have all been breached. That's what a German firm has founded. What exactly can you do to keep your financial data safe? How clean and safe is your credit card and debit card is what we'll be discussing. And finally, in our Spend with TMS segment, it looks like luxury realty is still holding its chin up, and property prices in the luxury segment are still looking good. The question is, if you have the money, should you spend it on luxury realty, and what's the top choice for HNIs when it comes to developers? That will be what we will be talking about on our Spend with TMS segment. So let's kickstart then the show with topic number one, and that is leaving a proper financial legacy. We often talk about will planning and estate planning, and such big names usually make us wonder that, look, if I'm just a simple salaried employee, do I really need to draw up a will? Is there a certain threshold when it comes to the net worth and the number of assets that an individual has? Above that only should you essentially have to create a will or plan your estate? Well, that's what we will try and answer. Who really needs to create a will? And if you do create a will, what should you ensure you include? What can you exclude? Do you need to involve a lawyer? We'll help you answer all of those questions and queries right now. We have with us Raghvendra Nath, MD of Ladderup Wealth Management. In fact, he's joining us right here in our Mumbai studios. Raghvendra, thanks so much. Really appreciate you joining us. We often say estate planning. It sounds like such a heavy word, right? It's like, okay, I have, these 3 properties in Delhi, and then another 5 properties here, and then I have this much money lying in my bank account, so on and so forth, and hence I'll make a will. But do you think that a will or an estate planning is needed for each and every individual, regardless of the number of assets they have, regardless of if they're salaried? Do you think it's something that each and every one of us should do?
I think so, yes. And in fact, the word estate sound, as you rightly say, a very big thing, and it's something which is a preserve of only the rich. But, just to think about somebody who has limited number of assets, he should actually make even, he should be even more confident that those limited assets are passed on to his beneficiaries or heirs in the manner that he desires. So will is something that basically anybody, whether you are a middle class person earning limited amount of salary or a retired person or a businessman, everybody should plan their wills, and more so because if you haven't planned a will, then the succession acts come into being. So whether it's, if you're a Hindu Succession Act; if you're not a Hindu, then Indian Succession Act, or in case of Muslims, the Muslim Personal Law. But then Succession Act will define how your legacy will be transferred to your heirs, and which may not be based your own wishes, So let's say if you want to give more money to one son and less to another, you can't do that in the absence of a will, If you don't want, let's say, no money to go to your parents, or let's say in case of Hindus, to their mother, and all the money has to go to their wives, then again you need a will. So the moment you want to basically move away from succession acts as such, then you need to have a will in place.
Okay, and so obviously this will supersede then any other succession act that you may be following, whether it's the Sharia law, the Hindu law, or whatever it is. Okay, now a very simple question. What's essentially the difference between estate planning and will?
They are one and the same thing. Okay. Will is a subset of estate planning. So, you can extend your estate plan to maybe include a private family trust. In case of businessmen, you may create a proper succession plan for your business management as well as, business succession. So, estate plan is a broad word which include all these things. Will is a subset of estate plan.
Okay, so will is an estate of, is a subsect of estate plan, pardon me. Okay, so what's step one then? And also very importantly, at what age? Because, I'm still young, right? Or at least I hope I look young to our viewers. But yeah, and obviously at this point, maybe when you're young, you haven't even accumulated so many assets, right? So at what stage in life should you then start creating a will? And then we'll, of course, talk on the steps.
So if you are, let's say, married, and you have children, then you need to start thinking about creating a will, because one of the key purposes of creating a will is to ensure smooth transition of assets, Okay. Typically, let's say, your assets are dispersed around various things, You may have insurance policies, you may have, like you mentioned, real estate, you may have a piece of land somewhere, you may have mutual funds, and so on and so forth. And for your heirs to actually consolidate all those assets and then transfer them to those beneficiaries is a very lengthy, time-consuming process, which can be shortened if there is a will in place.
Okay.
And the second big advantage of creating a will is that your legal heirs are aware of the assets that you hold, because typically in a will you would like to list down the assets that you have. Generally, especially in case of women who are not working. Generally, they are not aware of all the financial assets that their husbands have, Like if I were to ask my wife how many insurance policies do I have, she may not be aware of that, or the quantum of the policies, or where those policies are kept, okay, or how many bank accounts do I have, or how many demat accounts do I have. And in an absence of a will, she will be lost and she may not be able to actually figure out all the assets. So I was just looking at some data. LIC has something like 15,000 crores worth of unclaimed policies. Okay. Similarly, State Bank of India has another 13,000 crores of unclaimed fixed deposits. These people who passed away and their family members have not come forth to claim that money, And because they don't know that that money exists, that policy is lost somewhere, or that FD receipt is lost somewhere.
Okay, all right. And yeah, we often say this as well on the Money Show. For all the individuals out there, for their families, it's extremely, extremely important that you inform your families, your children, if they're old enough to understand, or your spouses, or anybody who would, be able to have that money to fall back on. They need to know each and every asset that you own, each and every bank account that you own, every property that you own. They absolutely must be aware, because obviously life is not not certain, and God forbid there's any unforeseen eventuality, they should not be left lurking and grappling in the dark. So this is extremely important, and hence the process of creating a will is extremely important. So Raghvendra, I'm not sure if you mentioned, when should one create a will, at what stage in life?
At any stage. I think the sooner the better, because will is not something that you are creating once and then forgetting about it. You can have opportunity to redraft or modify your will as you go along. So today, let's say you may have limited number of assets. Let's say somebody has young and only has one child. You may create a will right now, and then let's say his child gets married, then you may create another will, or if he has more children, then he can create, so there's always an opportunity to modify the will, and it's such a simple document, and it saves so much hassles that just, having that in place is a good hygiene factor. It's like, so many people have insurance policies, somebody gets into a job and the first thing that he does is buys an insurance. Will is more important than insurance, because insurance is only about, giving that your family a support when you are not there. But whatever you accumulated, all through the years that you are working, you also have a responsibility to pass that on seamlessly to your loved ones.
You worked so hard, you've accumulated that wealth, you ensure it's utilized adequately for the benefit of your family members. Okay, so I think step one that you mentioned in creating a will is listing down your assets, right? So what assets should be included? I'm surprised actually you mentioned insurance. It wouldn't have struck me. I would have first thought of all the tangible assets like your cars or your bank accounts or your property. So if you could just reiterate for our viewers, what assets should you include?
So obviously bank accounts, demat accounts, provident fund, land records, or houses or businesses that's there. You should also include things like your medical insurance. You may have a accidental insurance policy attached to your credit card, and your family will not be aware of that. You can add that so that your family can actually claim that money if somebody passed in an accident. Let's say an air accident. The family can actually get that benefit, if they are aware that the person who held this card and so much insurance was there. So all possible assets, whatever your income, whatever your assets are, and wherever in whatever shape they are, you can actually mention them.
What about debt? We talk about assets, but what about credit card debt, home loan, EMIs, etc.?
No, so you should actually. It's a best practice to mention the debt also. And in fact, when we create will, we generally, for people, if they don't have any debt, we like to mention that I don't have any debt as of now. So that, if somebody suddenly appears after the death and says that, okay, this fellow had borrowed 50 lakhs from me, that will is a proof that, specific that, he did not have any debt on the date of writing of that will.
Okay, so extremely important to just mention that one line, that I do not have any debt as on date. It's an extremely important line. You don't want tomorrow some individual just coming and claiming that he had borrowed XYZ amount from me. Okay, all right. I'm sure that when it comes to mentioning property, bank accounts, etc., I'm sure you'd want the individuals to mention the details as well of the assets.
Yeah, so generally, unless it's a matter of secrecy, people should mention both the account numbers and the kind of money that you own, because that gives an idea to the family to look around. So let's say somebody has 50 lakh rupees of total wealth, or let's say 1 crore of total wealth, and he has mentioned that. But when the family goes on to acquire, it finds only 15 lakhs. Then they can find out, then they can start hunting around where the rest of the money is, Has it shifted from one bank to another bank? Has the demat account been closed and opened in some other broker, which is not, they are not aware of? So they can actually figure out where that wealth has gone, and therefore mentioning both the quantum and the account numbers and everything is important.
Is also helpful.
Unless it's a matter of privacy or some kind of disputes, there are quite a few number of people who don't want to mention the amounts in the will,
Okay.
So.
Okay. What if my heirs, let's say I want to pass on the assets to my heirs, what if they're under 18? Do I need to then provide for a guardian for them or anything like that? Would you recommend?
I think that that's a very, very important question, and that's generally there could be disputes around the guardianship.
Yes.
And you would also like safety of your children and safety of the money, both the things. And therefore, you can, in the will, you can mention the guardianship, who could be the guardian of your children in case you are not there. There are other sophisticated solutions as well, like something you can create a testamentary trust, which is basically a trust which will come on on your demise in case your children are underage. Okay. And they are not adults. So if they are minors, then you can actually will proceed into creation of a trust. And all your money can actually go for the minors, and then that money can be held in the trust till the time your children actually attain adulthood.
So who manages the trust then? I mean, can I appoint?
So in that will, in the testamentary trust, you will also mention who are going to be the trustees of the trust in the case of your demise.
Now I want to talk about the legalities of this. I mean, can it be that, I just take a piece of paper and I write down that, okay, I own XYZ assets and they have this much money, and then I own this property, etc. And I say that this entire, thing will go, let's say, to my mother. And I just take that piece of paper and I sign it off. Would that be valid in the court of law? Can my mother then say that, oh, my daughter said that this all belongs to me and my mother can just take it? Would that be valid?
Yeah, so even a piece of paper on which you have written a will yourself will be a valid document. However, in case of, there could be cases where there is dispute around that will. So let's say you wrote the will, and in your mother, somebody comes to claim the assets that you basically had, and so in that scenario, basically, you may need to have a little better document, So let's say you need to basically have the document signed by two witnesses. Probably, it's always recommended that you take help of a qualified lawyer who's an expert in creating wills. Because while a paper will is valid, it may be challenged in the court, and in case and then if it's not properly written, somebody may just say that you wrote that will under duress, or under force. And you were forced to sign, on that will, and because there are no witnesses to that. So generally, you should follow a legal process, which is having a doctor's certificate attached to the will on which you signed, which will prove that you were in sound state of mind. You get two witnesses in front of you; they also sign on the will, and when you are signing, so there's a proof that you were not under any force. And on top of it, if you want to be a little extra careful, you should just go and register that will in a sub-registrar's office, because that sub-registrar then becomes a de facto witness. Okay. Because you have gone there, signed in front of him. Yeah, so it becomes a much more stronger document, where there will not be any disputes easily.
Okay, well, on that note, I'd like to tell our viewers as well that if you have any questions or queries specifically on creating a will, on essentially planning your estates for smoother transfer of your assets to your heirs, to your family members, you can call in 24990300. I think we've already got our first caller. Biman Chatterjee from Kolkata is joining us on the phone line. Hi, Biman. Good evening. What's your query?
Good evening. My query is on the probate part. Certain states in India, they have a rule called, the will has to be probated.
Okay.
And I have a feeling that is quite a difficult task. So if this can be explained, please.
Okay, the probate. Raghvendra?
So probate is basically a process where a court validates the will. Okay. And most institutions and government agencies would like to have a probated will, so that tomorrow if there's a dispute, there's no dispute, there's no room for any dispute. Once a court certifies that this will is valid and it's probated, then there will not be any disputes of any kind.
So it's basically that you take it to the sub-registrars
No. So this has to go to the court. Okay. So court has a process for probating a will. Okay. Like in Maharashtra, there's a fee attached to it, which is up to 75,000 rupees. There is there's a notice which is sent to all the persons who are mentioned in the will,
Okay.
or other legal heirs of the person,
Yes.
that's a notice is sent to them. You are asked to basically put those notices in newspaper also.
Okay.
And then you give an opportunity to anybody and everybody to basically come forth in case they have any objections to the will.
This is all while the individual is alive.
No, after the death.
After the death,
So
okay.
this probate is done after the death of an individual. So once you die, or once any person dies, then they basically take that will to the court to get it probated, which is basically getting a court certificate that this will is valid in all respects.
Okay. So this will, does it necessarily have to be signed by the sub-registrar, or like I said?
No, so any will can be taken for probate.
So does it necessarily mean that if the will is taken for the probate, and if I take it, I have a problem with, an area of the will where I believe that, this bit is unfair or something?
So court will not basically go on the contents of the will, but let's say if somebody comes and says that this asset did not belong to this guy, he has willed this asset to his son, but this asset belongs to me, or this was a inherited property in which he could not have, basically there were other inheritors to the property and not only this guy.
So the asset is not in dispute.
Yeah, so the court basically gives an opportunity to the people to come forward and say that if they have any problem, and then if somebody comes, and forth and let's say files a kind of objection, then the court basically then takes it and hears it and then passes its judgment.
A judgment, okay.
So that process, if it gets into disputes, it's a little longer process.
Okay.
But if it's a simple will, let's say, and let's say the gentleman who was asking, let's say there is no dispute, and it's a simple family, everything is fine, and limited number of assets, and so then probate is a very simple process. Within 6 to 7 months, you should actually be able to get a probate.
So some banks and financial institutions do ask for a probated will before the heir essentially comes and maybe withdraws the money or whatever it is. So it's not compulsory though, nevertheless.
Yeah, it's not compulsory.
Okay, all right, great. Okay, if you guys have any more queries on will planning, estate planning, do call in. I think we've got one more caller, Japesh from New Delhi. Do we have him with us? Hi, Japesh. What's your question today?
Yes, thank you very much for taking my call. This is with regard to the preparation of a will.
Yes.
I wanted to find out whether, there are two basic components. One is a physical asset and the other is what you call as a financial asset. Now, if I start listing out the details of financial asset, let's say tomorrow morning I decide that I must have a will for my son. Now, once I start listing out and quantifying my financial assets, whether it is mutual funds or shares or life insurance policies, okay, life insurance, there may be an element of consistency.
True.
But, if I live for another 20 years, and certain things could get redeemed, certain things could get sold out. So then how soon can I keep on updating that?
The will, true.
So that becomes some kind of a problem to me. And if I'm living for myself for another 20, 25 years, how many times do I need to revise that? Because the figures will change the very next day.
Of course, values of properties, shares, mutual funds, it all changes.
Exactly. And secondly, a quick question. If I go to a sub-registrar's office with a piece of paper, even if I type it out, is that okay? Or does the sub-registrar give me a stamp paper on which I have to follow a particular format? How do I get it registered exactly with the sub-registrar's office?
Yes,
so I'd be grateful if you could please give me some idea about these questions.
Yeah, valid questions, how soon should you update your will, especially when, like you mentioned, you can make it at any age. If I say to make it now and hopefully, if God willing, I have a long life, 40 years later, the values will be completely different, right?
True,
so,
true.
What would you go
to the first question, basically, as I was mentioning, the purpose of quantification of assets is to help your family. And obviously the value of the assets will keep changing, and generally when we write wills, we write to some effect that these, and we mention that these values will increase or decrease, and the proportion of so we rather work on the proportion in which the allocation has to be done, or fixed and not fixed amounts.
Okay.
So I will not say I'll give 25 lakhs rupees to my son and 25 lakhs to my wife.
Okay.
I'll say I'll give 50% to my son and 50% to my wife.
Okay.
So like that. And then you basically put these assets in an annexure. So you keep updating your annexure. So annexure is basically part of the will, but annexure is more of a guiding document. It's not the will itself.
Okay.
So you create the list of assets as an annexure. And you keep updating the annexure every now and then. You keep attaching a new annexure to your will,
But then won't that also have to
No, so you don't have to go to the registrar for that, So you
okay.
just keep on updating the annexure and attaching it to the will. This is the new annexure,
So, okay, just a quick question. Is it necessary for me to constantly keep updating the annexure also?
Not necessary, but
Okay.
it is recommended, as this gentleman was saying. Let's say today you have 1 crore of assets, and after 5 years you have 5 crores, then there is a big difference, and therefore you'd like to update the annexure.
Okay, just his second quick question on format for when you're going to the sub-registrar.
So, first of all, there is no stamp paper required in case of a
Okay.
will. So, you can write it in a piece of paper, but there are certain best practices.
Okay.
In fact, if somebody Googles, you can find out hundreds of formats on the will, on Google, on how to write a will.
So no stamp paper, no franking also
No
as such
franking,
required.
nothing is
You can
required.
just take a regular A4 size paper, type it down, note it down, but just go to the sub-registrar and sign it before him.
That's right.
Do not pre-sign and
That's
go,
right.
basically.
Yeah.
Okay. Great, Japesh, I hope this has helped you out with your query, but we are out of time, so we'll not be able to take any more calls or answer our email queries. Thanks so much, Raghvendra, for joining us. It certainly was a very enlightening session. Guys, a will is more important than an insurance, because if you have an insurance, your family will just get that insurance amount. If you do not have a will, they will literally get none of your savings. So make sure you go home and prepare that will, list down all the assets that you have, and get it signed with a sub-registrar. We will take a very short break, but when we return, we're going to be talking about the latest round of financial data breach. The question is your credit or debit card safe? How can you instantly check that your data is not being swindled? Stay tuned to The Money Show.